History at its best illustrate the following event in the previous years of the Philippine history. Ex-Senator Hubito Salonga, himself a victim of a still unresolved and heinous Plaza Miranda bombings, was arrested at the Manila Medical Center while hospitalized for bronchial asthma. When arrested, he was not informed of the nature of the charges against him. Neither was counsel allowed to talk to him until this court intervened through the issuance of an order directing that his lawyers be permitted to visit him. Only after 4 months of detention was the petitioner informed for the first time of the nature of the charges against him. After the preliminary investigation, the petitioner moved to dismiss the complaint, but the same was denied. Subsequently, the respondent judge issued a resolution ordering the filing of an information after finding that a prima facie case had been established against all of the 40 persons accused. In the light of the failure to show prima facie that the petitioner was probably guilty of conspiring to commit the crime, the initial disregard of petitioners' unconstitutional rights, together with the massive and damaging publicity made against him, justifies the favorable consideration of this petition by this court. With former Senator Benigno Aquino Jr., now deceased, there are at least 38 other co-accused to be tried with the petitioner at the court. The prosecution must present proof beyond reasonable doubt against each and every one of the 39 accused, most of whom have varying participations in the charge for subversion. The prosecution's star witness, Victor Lovely, and the only source of information with regard to the alleged link between the petitioner and the series of terrorist bombings, is now in the United States. There is a reason to believe the petitioner's citation of international news dispatches that the prosecution may find it difficult, if not impossible, to bring him back to the Philippines to testify against the petitioner. If Lovely refused to testify before an American federal grand jury, how could he possibly be made to testify when the charges against the respondent come up in the course of the trial against the 39 accused? Considering the foregoing, we find it in the interest of justice to resolve at the stage the issue of whether or not the respondent judge gravely abused his discretion in issuing the questioned resolutions. The respondents contend that the prosecution will introduce additional evidence during the trial, and if the evidence by then it is not sufficient to prove the petitioner's guilt, he would anyway be acquitted. Yes, but under the circumstances of this case, at what cost not only to the petitioner but to the basic fabric of our criminal justice system. The term prima facie evidence denotes evidence which if unexplained or uncontradicted is sufficient to sustain the proposition if it supports or to establish the facts or to counterbalance the presumption of innocence to warrant a conviction. The question raised before us now is where the evidence against the petitioner uncontradicted and if they were unexplained or uncontradicted, would they standing alone sufficiently overcome the presumption of innocence and warrant his conviction? This is part of the history which I shared for the interest of the people around, because history sometimes may be repeated, as the saying goes, but it is important to familiarize some history in the political movement, as well as the court of our land, based on the constitutional concepts and mandates. Thank you.